Project. I'm just your chair for the morning, and so I'll be doing the introductions and some of the timekeeping. Hopefully we won't have any timekeeping issues. Today we have a really interesting collective of people giving presentations. So we have international experts and academics, we have criminal justice practitioners, and we have people who have experiences of decision making in the criminal justice system. So, for me at least, this is a really interesting and exciting workshop, because most workshops we don't get to experience a whole range of different people coming together and discussing the same issues. So I guess the key issue today is criminal responsibility, the application of the CRPD to various components of the criminal justice system, like defence of insanity and unfitness to plead or fitness to plead, and I guess the challenges that creates in terms of creating a disciplinary neutral environment, and how to have a criminal justice system that is cognizant of all those issues while maintaining kind of the main process, which is criminal responsibility. So for me at least, it should be really challenging and exciting to gain some perspective on those things. I mean, I'm not something so familiar with myself. So first up is the manager curator of the project, Dr. Eleanor Flynn. She'll do the opening address, and then after that we'll start the presentation.
Thanks very much, Diarmuid. So welcome everyone. I just wanted to tell you a little bit about the project for those of you that are new to the Voices project, and a little bit about why we're having these discussions today. So the Voices project is funded by the European Research Council, and when I came up with the idea for the project, what I was really trying to do was explore the real life stories of people who, for various reasons, have either been denied the opportunity to make decisions for themselves, or have managed to, under very difficult circumstances, make decisions for themselves using different kinds of support. And I was becoming very frustrated in a lot of the discussions that were happening around the world with policymakers, with decision makers, who were definitely interested in changing their laws and policies and thinking about new ways to do things. But I felt that when I was invited into those rooms anyway, as a researcher or as an academic, I wasn't really seeing many people with lived experience in those rooms, and if they were often on their own in those rooms, or they were often there in a tokenistic way. So I wanted to design a project that would be quite different, and that would really put people's real experiences at the heart of ideas about why the law should change, why the systems should change, and that's what we've tried to do in the Voices project. So over the last year and a bit, we have been putting together pairs of what we call storytellers and respondents. So our storytellers are people with disabilities, people with lived experience of different kinds of restrictions under the law, and our respondents, again, some of whom also have lived experience of disability, but also bring a wealth of perspectives to that person's story, and can help that person jointly, together in collaboration, to figure out what should have happened differently, what they would like to see happen differently for other people. So we have now made 15 pairs of people. I originally said I would make 8 pairs, but we just found so many amazing stories that we couldn't say no to people. So we now have 15 pairs from 11 different countries, and at our workshop here in Galway in April, we brought people together for the first time to work together in pairs and to think about how the law affects their lives on a range of topics. So in a way, we're starting with the hardest one first today, with the criminal responsibility seminar, but we will also be looking at people's real lived experience of the law of contract, and we'll also be looking at people's experiences of consenting to or refusing medical treatment, and consenting to or refusing sexual relationships. So those will be in our upcoming workshops. We're having the workshop on contract on the 17th and 18th of November here in Galway, and the medical treatment workshop is going to be the 10th and 11th of January. So keep an eye on our website, which is ercvoices.com, for more information about how you can get involved in those events. I just want to say a few words about the people who are presenting today in general as a group, and Diarmuid's already mentioned that we've got a diversity of perspectives in the room, which I think is really valuable. But we've also got a diversity of countries represented in the room. So our storytellers and respondents, as well as the various members of our advisory board for this project who are participating in our discussions today, come not just from Ireland and the UK, but also from Croatia, from Spain, from India, from Hungary, and from Argentina. So we've got quite a lot of experience in the room and a lot of different perspectives on how the law could be designed, and I think that would be really helpful for our discussions. I just want as well to thank particularly the people who are sharing deeply personal stories with us today. And I think that from discussions that we've been having in the run-up to this event, I've been always fascinated and amazed by people's ability to tell such personal stories with such warmth, with such humour, and to find the joy and the light in experiences that other people might perceive as very difficult or even tragic. So I think it's really important to remember that people have chosen to share these stories with us, and it's our duty and our privilege to listen to these stories with respect. And I know that that's what everyone who's in this room today is here to do. So I just want to make a few quick announcements before we get the event underway. One is that for anyone who needs it, we have a quiet room if you need to just step out of the space and clear your head. As you make your way back to the foyer and towards the cafe, you see the quiet room is signposted on your right, and it's open all day. If you want to use it, just go inside and you'll find a sheet in there that you can stick up on the door to indicate that it's in use. Tea and coffee will be served in a room on this corridor, G005. So if you go down the corridor, you'll see the entrance to the tea and coffee room on your right at the morning break, and after for lunch and for the afternoon coffee break, they'll be served back in the foyer. Fire exits. So once you exit this room, you'll see a fire exit on your right. We're not expecting any drills today, so if the alarm goes off, we all do have to leave. And once you get out this fire exit, if you turn left and cross the lawn, you'll see where the fire assembly point is in front of you, and there'll be plenty of volunteers to guide you if that's happening. And just for any of you who've parked here, to make sure that you have parked in a pay and display space, which is between the blue lines, and that you have displayed a valid ticket. So we're also hoping to get evaluation sheets back from everyone at the end of the day. There's a box on the registration desk for people to add them into. On the registration desk, you'll also have seen the biographies of our speakers if you're interested, and we have some plain language abstracts for the people who are going to present today. Charlotte is busy tweeting at the back of the room, so if anyone wants to join her, you can tweet at ERC Voices using the hashtag CrimResp, and that will be for today's seminar. And I think, unless I've forgotten anything, Cleena, that is everything. So without further ado, I'll hand back to Diarmuid to introduce our first speaker.
Thank you, Eleanor. So our first speaker this morning is Dr. Florence Heglin, and Dr. Florence Heglin is a professor of criminal law at the University of Buenos Aires, and she has acted as a public defender for 14 years, so she's an academic and a practitioner. Her research focuses on the human rights of persons with disabilities in the criminal justice system, with a particular focus on confinement of those not guilty by reason of mental illness, and her paper today is entitled Rethinking Criminal Responsibility in Light of the UN CRPD.
Good morning. First of all, I would like to thank the organizers for the invitation to this workshop and the opportunity to share my experience and my ideas with you. My name is Florencia Heglin. I am from Argentina. I am from Buenos Aires. I worked as a public defender for 14 years. I defend people who are accused of a crime and prefer to be assisted by a public defender. In my country, in 90 criminal cases, people choose a public defender. And today I'd like to share some ideas that are the synthesis of my experience as a defender of people with disability who are subject to a criminal process. In particular, I will present what is happening today with them and how people with disabilities, obviously, and how all of them suffer on their rights, their bodies, and their dignity, the state punitive power. Moreover, I will introduce and discuss some proposals to overcome these right violations. Next, please. I will divide my talk into 3 parts. First, I will introduce a few previous issues that must be fully taken into account and incorporated to the discussion. Second, I will present the current criminal process and the right violation. And third, proposals and observations. I shall only take 30 minutes of your time, and I'll be glad to answer any question at the end of my talk. And I hope that these reflections will act as a good springboard for discussing feasible reforms to the criminal justice systems that are necessary, in my opinion, according to the CRPD and according to the human rights system in the world. Let's start. Next, please. First of all, we must have a clear picture of every criminal process. Unlike the civil, commercial, or administrative processes, in the criminal process, the citizen doesn't pursue a legal claim or a complaint. They are not demanding the payment of the debt or some damages. They are subject to a criminal prosecution by the state punitive power, and they are accused of having committed a crime which they might not have committed. Thus, if they don't want to be unfairly punished, they must defend themselves, and they must get a proper and fair legal assistance. Moreover, the consequences of this process are irreversible and irreparable. Defendants lose their liberty, but they also suffer a daily ill treatment, torture, and humiliation in prisons and over the process. Their families suffer with them. And finally, we should remember that the prison is not always the consequence of a guilty conviction. As we know, the pre-trial detention is a very usual mechanism in every criminal process. It's usual to see defendants who are declared non-guilty and released after a long-term detention being innocent. Due to these special characteristics in every criminal process in the world, the defendants have specific safeguards, which are not recognized in other processes. In this direction, we will precise there are different types of legal criminal processes in the world, which are guided by different rules and are framed under different political ideologies. We might want to consider the differences when we think and discuss about reforms. Next, please. Mirjam Damaska, a professor of the Yale University, in this book, The Faces of Justice and State Authority, this is a book I strongly recommend to everybody with an interest in studying criminal processes, develops a comparative analysis of judicial procedures around the world, and he examines the political ideologies behind them. This author uses two models in order to examine the political ideologies behind each kind of process, the active state and the reactive state. In the active state, next please, the government has a managerial function, and the administration of justice is devoted to the fulfillment of state programs. The process corresponds to the continental administration of justice, and it's known, as you know, as the inquisitorial system. Its main objective is to uncover the truth, and in order to uncover the truth, the prosecutors, the judges, search for evidence, and they question witnesses, experts, and defendants. Parties are considered as a source of information, thus they can readily be converted into objects of investigations. We have a lot of cases in European and Latin American criminal proceedings where the defendants were forced to make statements and to answer police questioning. In this system, the duty to answer quickly has turned into confessions obtained by torture or by compulsion or in misleading statements. In this, no, please. I represented in these slides the small defendant because he's small and he's most of the time in prison, in pre-trial detention, at the biggest state against him. In order to prevent this unfair practice and to limit the power of the state, the national law and the international criminal law have recognized procedural safeguards. And one of these safeguards is the safeguard to have an effective participation in full equality, or the right to defense. Next, please. In the reactive state, which exists to maintain social balance and to respect the laissez-faire principle, the focus of the judicial system is on conflict resolution. This process corresponds to the Anglo-American, your administration of justice, and is known as the adversarial system. In this model, it's not important if the resolution approaches to the truth, as Damascus says, because the main objective of the criminal process is to resolve the conflict between the accuser and the defendant. The process unfolds as an engagement between two adversaries before a relative passive decision maker, the jurors. Under the system, the two adversaries take charge of the process, thus the defendant becomes one of the active parties. In this model, the dispute must be played by rules and the rules must be fair. As Damascus says, the problem is to balance the power and the advantages and the disadvantages of the litigants, to provide equality between them. But the balancing act has a problem when one of the parties is the state, with all the resources that the defendant has not. Where the state is a party, the standards in our criminal system, the full procedural symmetry is seldom attainable, and the disadvantages increase when the defendant is a poor person, the standard is a poor person, or belongs to a group of invulnerable situations, without resources to balance the power of the state. Aware of the risk of punishing an innocent person and to balance the power of the state, the system also includes procedural safeguards. And one of these safeguards is the effective participation in full equality, the right to defend. In conclusion, as we can see, there are substantive differences in each model, however, both of them recognize safeguards. If these safeguards are fulfilled, the process will be fair and the conviction sentence will be lawful. But if these safeguards are not fulfilled, the process will be unfair and the conviction sentence will be unlawful. Finally, if you are talking about the right to an effective participation in full equality and people with disabilities, we must take into account the CRPD. In my opinion, three articles are especially linked with this issue. Article 12, 13, and 14, and the article, next please, 5. As a cross-cutting principle of this convention, we must remember that this article includes the right to not be discriminated and the right to, and this article also includes that the specific measures which are necessary to accelerate or achieve de facto equality will not be considered discrimination. That covers our first part. We could see the special feature of the criminal process. We could see the difference between each model and the effective participation in full equality as a safeguard, and we could see the article linked with this question. Now we will see if this theory is applied in the criminal process. So, if the criminal processes today recognize or not recognize these safeguards. Next, please. I will take the current Argentinian system as an example, but I think that is very similar to other criminal systems according to what I've read in the committee reports. There are a lot of, next please. There are a lot of persons with psychosocial disabilities in the criminal justice, and with other disabilities also. They are accused or condemned to having committed a crime, and most of them are in prison or in a mental institution. As we know, most of them are subject to trial. A few of them are acquitted due to lack of evidence, and the others are convicted without due respect, in some occasions, I will explain, for the right to have an effective participation in full equality. There are different justifications to explain, next please, these negative conclusions. On the one hand, some traditional authors point out, following the medical model, that these defendants were subject to a trial when their disability had prevented them from exercising their rights. On the other hand, others point out, following the social model, that the restriction was not the disability but the lack of measure to exercise this right appropriately. After the CRPD, we must agree, obviously, with this last point of view. But we should remember that defendants with disabilities are subject to process with very little information of their procedural situation. As an unusual example of the cruelty of the system, we often see that defendants with especially intellectual impairment confess to a crime and agree to a short-term trial procedure in which they give up the right to a trial and accept a punishment under threat of a more severe penalty, being innocent. Better known, this mechanism is better known as a plea bargaining mechanism. The big problem, is that they make this critical decision for their lives without accurate information of the real meaning of this institute, of the real scope of their confessions, and of the real and heavy consequences of the penalties that they accept. The criminal process is not accessible to defendants with or without disability, neither to the witnesses. The investigator questionings, the forms, the sentence, and the records with the release commitments, the judicial communication, among others, are not written in plain language. The judicial language is obscure and complex, and sometimes it appears aimed at misleading defendants. Moreover, we must remember that the state punitive powers always wants to resolve the cases quickly. And if the defendants give their confessions, the cases are easily resolved and the investigation can go home. As a result, next please. No, thanks, that's okay. As a result, we must conclude that most of people with disabilities are convicted without an effective participation of them in their processes. Therefore, the processes are unfair and they are certain to condemn an innocent person. The lack of universal design of a criminal process and the lack of appropriate measure and the lack of support in the process violate Article 12, 13 and 14 of the Convention. On the other hand, next please, a smaller group with most of time severe mental disabilities, sometimes with memory disorders, is considered without possibility of participating meaningfully and in full equality with others in the process. They are considered unfit to plea or unfit to stand trial, and their processes are suspended. Defendants are confined, and they are absolutely forgotten in prison or in mental institution. Many human rights are violated. Next, please. First, the right to have a final resolution in a reasonable time, the presumption of innocence, the limits that every pre-trial detention must comply. For instance, this year, I defended a man who had been in the psych ward of a prison for 12 years waiting for a trial, which had been suspended due to his mental disorder. If he had not been diagnosed with this mental disorder, this pre-trial detention would not have lasted so long, or it might not have applied. Moreover, my defendant deemed unfit to plead and ended up being in prison longer than if he had been guilty. The judges made differences because of his disability, and this is discrimination. In this respect, the Article 14 of the CRPD is also violated. I will speak later about Article 12 in particular. After describing this right violation, we can recognize two very important focal points to pay attention. First, the still remaining violation of the right to an effective participation in full equality. Second, the CRPD rights violations. Let's leave the current right violation, and now I will present two proposals of criminal law reforms in my country, and I think that they are similar to other proposals in the world. Next, please. In order to promote a greater recognition of the right of the effective participation in full equality, some traditional authors following the guidelines of the medical model have proposed to extend the scope of the unfitness to stand trial. However, they keep the confinement as a consequence. Next, please. Therefore, this proposal brings more damage than protection. On the one hand, the defendants will not be able to participate in the trial even if they want to, and even if they are able to do with universal design process and with appropriate support and with appropriate reasonable accommodations. In this point, this proposal violates Article 12, 13 and 14. On the other hand, the confinement, which violates, as we have seen, the human rights system and against the Article 14. In conclusion, this proposal is not good enough. We've seen how the safeguard becomes a dangerous safeguard. Now we will see Proposal 2. Proposal 2 was developed in my country. It was developed in a new Code of Criminal Procedures, which was sanctioned last year and was suspended last year too. Yes. Last year, a new conservative president was elected in my country, and I think that it was the third decision that he took. The third decision was suspended this new Code of Criminal Procedure. Argentinian legislator interpreted that, next please, that the support-assisted decision-making model obliged them to eliminate the unfitness to stand trial. Therefore, all defendants always have to stand the trial. Always. This proposal set two positive consequences. The best, accessible procedure and support must be provided. The procedure must be accessible and the state must provide support and reasonable accommodation when necessary. Second, the defendant's confinement was eliminated. However, we should consider some risks, in my opinion, of this reform. First, in the current criminal system, support for persons with intellectual disability, supports for persons with intellectual disability don't exist. Thus, judges and lawyers are not used to dealing with this kind of measure. They are not prepared to deal with this new paradigm of the convention. Thus, this proposal has the risk of becoming only a cosmetic change. Second, the suspension of the proceedings was eliminated too. Thus, defendants are always subject to trial, even if the support or measure are not enough or are not applied properly. And this is a problem to me. In this system, therefore, in my opinion, the complete elimination of this rule and the suspension of this process will cause unwanted effects and new defendant rights violations. In my opinion, they eliminate a safeguard to avoid state abuses and to limit or balance the state power. The suspension in severe and extraordinary cases, especially when there is a memory disorder, is not an act of discrimination but a safeguard to avoid a trial in violation of rights. CRPD is a Bill of Rights and must never be used as a bill to condemn innocent people through an unfair trial. The state must never use argument to protect the rights with disability to damage them. We should take into account that the elimination of the suspension could trigger wrongful convictions with an innocent person in life imprisonment. It's necessary to take into account that it's very difficult to generate doubt in the judges or in the jurors without knowing the defendant's story of what happened. Second, this proposal makes, in my opinion, a partial reading of the Article 12. The state obligation to recognize that person with disability enjoy legal capacity must not be interpreted as a permission for the state to punish them unfairly. In my opinion, the defendant must be considered as a whole, and the disability must consider as one of all the situation of vulnerability. We have to abolish the psych diagnosis. We have to think the person as a whole, with his or her environment, with his or her family, with his or her support, or without his or her support. We should remember that this Article 12 in point 4 establishes that the measure and support must respect every right of person with disability, and one of these rights is the right to defend and the right to have an effective participation in full equality. We have to remember, or we have to take into account, that this is a process where a person could be punished being innocent. After this observation and reflection, I think that I should tell about my proposal to discuss with you. I think that as the current criminal process, the state must guarantee the trial, but also the suspension of this trial when effective participation is not ensured. However, we have to make dramatic changes to the current criminal process. We saw this, the violations of the unfair I explained, and Article 12 in point 4. Current right violation. We've seen the current right violation. I think that we make dramatic changes according to the CRPD and according to the human rights system also. First, next please. First, state must ensure accessible procedures and support. Next. Accessible. The process must be accessible for everyone. And the process must recognize the possibility to design, to appoint a support to everyone. The criminal law must be reformed to include the universal design of criminal process and appropriate measures. It will be necessary also to think of training programs to judges and lawyers about the exact meaning of these measures. I am sure that the design of an accessible criminal process in plain language that includes reasonable accommodation and appropriate support when necessary will facilitate decision-making in trial and limit, reduce or eliminate defendants' pre-trial detention and even their convictions. The trial will be fair and next please, and will ensure the requirements of the CRPD. On the other hand, the unfitness to stand trial must be regulated as a subsidiary rule. First, appropriate support, and second, if they do not guarantee effective participation in full equality, and only in that cases, previous support, previous accessible, previous reasonable accommodation, only in this case, defendant must be considered unfit to stand trial, and the process must be suspended. However, this suspension must include time limits. Next, please. In accordance with the right to have a final decision in reasonable time. And the most important to me, the suspension of the process must never include the possibility of confinement due to disability. If the judge orders a confinement, it must be ruled by the same limits of every pre-trial detention, flight risk or interference the investigation. In other words, it will be discrimination. Next, please. I think that this reform will end the human rights system violation and CRPD also, CRPD violation also. Before we move on to question, I will briefly summarize the main features to guarantee rights in the future reforms of criminal processes. First, universal design. In my country, we don't have a universal design of the criminal process. Second, appropriate and enough support. And third, only if the appropriate and enough support is not enough, the unfitness to stand plea rule, with limited suspension and without and never confinement. Thank you very much for your attention.
like to welcome myself. I'm Nick Clark. I was diagnosed with Asperger's syndrome in 2004. She's on, yeah, yeah. Closer, yeah, okay, that's it, that's right, okay, great. This is my first presentation, so if I stumble a bit, then apologies. I'd like to thank, first of all, ERC Voices, Eleanor, Leona, for inviting me over, and having a respondent now, she's like, it'd be a great pleasure to have her as well. We've been working well together, so yeah, so I'll start. So, like I was born and raised in Birmingham. I studied horticulture at college, Horticulture College in Herschel in Worcester, and became a golf course greenkeeper. And then I introduced with my sister, who's Ginny-Elle.
Hello. I just wanted to say that Nick's from a close, loving family. There are 8 of us, and he's the youngest. He's got 6 older sisters, poor boy. As a child, Nick was a quiet, happy, and very content child.
Okay, yeah. That's yeah. Yeah, like I said, okay, yeah. So basically, the whole thing started. Basically, my breakdown started. Something very minor, like buying a brand new car, which was the wrong number plate, basically. And that was in April 2004. So, and then I started to get into the deep depression gradually, and you can see on the list there, that was 4 months after my breakdown started. That's when I started to go downhill, basically, and I wrote this with my older sister, the list. So I'd like to go through the main ones. I felt rebellious, scared, afraid, don't like looking after myself, and I was afraid to see other people. So those were the main things. And the doctors and social workers thought I was putting it on, was attention seeking and being naughty. That's what they thought, the psychiatrists as well. So rather than mental illness, it was like attention seeking. So yeah, I was diagnosed with Asperger also in September of that year. So and then, yeah. November 2004, my dad was diagnosed with leukemia, cancer of the blood. So, and he was told he only had a few weeks to live, but he actually lived for over a year later. Another year, actually. Yeah, that's right. To November 2005. Okay, and then I'd like to go back to continue.
At this stage, basically, Nicky was given a cocktail of medication, which were antipsychotics and antidepressants, and his personality completely changed. He became more and more angry and aggressive. His behaviour was out of control, and he started smashing up the family home. He was howling. He kept repeating the same things over and over and over again. And at this time, the police and social worker were involved. And Nick was told he had to move out of the family home, and my parents were told not to let Nick through the front door.
Okay, great. So then, well then. Well, that's where I started from, January 2005, yeah. So basically, one morning I was having breakfast and suddenly got a knock on the door, and the social worker turned up, the police officer. There's no warning beforehand. I was told I had to move. I got 20 minutes to pack up and leave. So that was actually across the road. Hospital 1 was directly opposite my parents' house, which didn't help because I could actually see the house. So, and also I was reluctant to leave. So I think that's, and then yeah. In the hostel 1, yeah, what happened there? In the hostel 1, there was they had no structural routine. There was limited help and support. The warden kept on calling the police for minor incidences. And one incident that I particularly remember was physically assaulted when I was in my bedroom, refusing to go to work. The manager got the service user punched me in the face for not getting out of bed. So that was quite shocking. That caused me to get more upset and aggressive as well. So, and then hostel 2, basically I was evicted because of my behaviour. They couldn't cope with my rages, basically. So I was moved to a hostel further down in Birmingham, in another part of Birmingham, 3 miles away. And over there, they did have no structural routine as well. And worst of all, they had no, I was self-medicating, I was in charge of my medication, so no one was in charge, none of the staff were responsible for the meds, and they also verbally bullied me. So, prison? Yeah, that's fine, yeah, that's fine, yeah. And then that's right, yeah. And then, I think that's of course the medication there, that's all the medication you see, yeah. And all the hostels lacked routine, had to manage my own medication, as I said earlier. And also I started to self-harm by like stabbing myself on the top of my leg so no one could see. So that was just like to, I think basically I did it to get the anger out of myself and just felt better at the time, so to get the stress and anxiety out, so yeah. And then this is, it goes back to Hostel 1. I went back to there and, because it was close opposite my parents' house, and started to break some flower pots, and the police were called. And then a few, that's right, yeah. And then a few days later, I'm trying to think now, that's right, yeah. That's right, yeah. I was trying to think that first. That's basically the Hobby Path knife is, was when I was outside Hostel 1, threatening to self-harm, and the police were called, and I was actually taken to police station, and I was told to do one sister, you can maybe explain briefly about it, because you were a lawyer, just to say, because you said it's quite important now.
Nick was carrying a knife. I think that's exactly the kind of knife.
That's kind of a Hobbycraft knife, yeah, against
very small blade.
Yes.
And arrested and taken to police station and interviewed without a solicitor present. And then they offered to caution him for the offence of carrying an offensive weapon with intent to harm, which is a very serious offence. And he accepted the caution for this serious offence without having received legal advice at any point. And now obviously that's still on his criminal record at this time. And any time he applies for a job where they look at his criminal record, they can see that he's previously been cautioned for carrying an offensive weapon. Even though the offensive weapon is a little yellow knife you can see there.
Yeah, sure. Hostel 3, yeah, Hostel 3 wasn't very nice at all. It was like, the staff were also like verbally, giving me sort of physical threats, and I think one day I just had enough, and actually I would say that first, yeah, like, the 2 days before my arrest I was following one of the staff down the road with a plank of wood, basically, and the police were called, and then I was restrained roughly and then cuffed, and then one of the police officers deliberately several times put his arm against my throat until I started choking, and he did this like several times in the car as well. So that was daunting, and then had to spend a few hours there, and then basically 2 days later, cut long story short, I ended up having like another meltdown basically, and started, I smashed a reinforced glass panel door, and then they tried to restrain me, the staff, so I started pinching and scratching the staff members, and then they called the police, and I was arrested and I was put in prison. I was in that's right, in the police station for like 2 days, 2 whole nights, and they, before I went to, they were charged, as I was charged with criminal damage and actual bodily harm. That's what their charges were against me. So, move on next. Yeah. And then I basically I was spending 2 nights at when I went to Birmingham Magistrates Court, where I was told by the solicitors to plead guilty. I wasn't like given an option to. He didn't ask me if I could plead guilty or not guilty. He never gave me the option. So yeah, that's right. Then I was remanded in prison for 3 weeks, and that's right. Yeah. Yeah. Then 3 weeks later. I should briefly mention the prison. When I went to the prison reception area, they asked me, do I feel suicidal? And I said I do, and then the prison officers started making fun and joking about it, laughing and joking, smirking, so that didn't help, so that made it worse. So, and then after that, basically, I was on remand for 3 weeks, I went back to Birmingham Magistrates Court, pleaded guilty, and then there was no like place for me to stay at. There was no specialist unit, so I had to go back home basically. And then I ended up going to the Milton Park Hospital in Bedfordshire, UK, England, and that's where I started to recover after 7 months. I was there for 7 months. So. Actually, I was coming off my medication as well, that's right, yeah. So yeah, I came off my medication gradually, so as well, that helps. Gradually, I was on like 7 medication at one point, so I went down to 1, so. No. Okay.
Can I just point out, just at that time, there was just no help at all for Nikki, a young adult with Asperger's. And they said they could only look after Asperger's if they were a child. And basically, getting to the home for Asperger's syndrome took a lot of research and hard work from all the members of the family, all trying to get Nicky back to how he was.
And then, oh yeah, now, I could come to the, yeah. What do you do now? Okay, yeah. Now, that's right. I'm now actually managed to, after, basically I left work in 2008, in June 2012 after being bullied by the manager, so I decided to like, gained my qualification in Maths and English, and then also got some qualification in childcare and autism awareness. So that was quite good. And then I started to, because I've got Asperger's syndrome myself, I thought I can understand other people on the spectrum. I get on with like kids because I've got 11 nephews and 4 nieces, so I've always been good with young people. So I thought it'd be a nice job to get into, but because of my previous conviction, it's proven hard to. But the picture there, that's where I'm working, where I'm volunteering at the moment. So that's that's in South Birmingham, like as a play worker, once a week on a Saturday. So which is good. So that's like hopefully in November, I'm hopefully get a job with them. So that's not all doom and gloom. So that's where I studied in Fairfield Centre in Worcester, in England. So that's like a small adult education centre, which is nice. And then that's another place I volunteer at. That's a Christmas party 2014. So yeah, work in the shop as well. Yeah, like an autism Birmingham shop, charity shop, to provide sensory equipment for children on the autistic spectrum. So.
And he keeps bringing me lots of things from the charity shop. So my house is completely cluttered now. Keeps thinking Ginny will like that, Ginny will like that.
You do though, anyway. Okay, is that all done? I think, yeah. Okay, it's finished before, yeah.
So. It's been really, tell me from that man, it's been really, really interesting getting to know Nick and getting to know his family and hearing his story. It's also been really frustrating because I started working with adults on the autism spectrum when I left school in 1998, and these issues about adults who have high-functioning autism not having their needs identified and then being a lack of services, that was very topical in 1998. Nick had his breakdown 6 years later in 2004, and still in Birmingham, which is the UK's second largest city, there was no specialist service, there was no psychiatrist working in adult mental health services who could meet Nick's needs. He was actually, you were diagnosed by somebody by a child psychiatrist.
Yeah.
And then once they'd completed the diagnosis, they just referred you back to adult mental health services, and the way they supported you was to keep prescribing more and more medication, and that was it. And not surprisingly, Nick didn't find that very supportive, and Nick's mental state deteriorated, and he felt more and more unhappy because he wasn't receiving anything like the appropriate support. But this isn't a problem people didn't know about, this was a well-known issue. And that's 10 years ago. I don't know if things have improved since then, I'd like to hope so. But the other thing that's really frustrating about it is that it's not the case that Nick was a very isolated individual in the community and nobody was telling the social workers or the doctors what the problem was. Nick has a folder with copies of all the letters that his sisters and his brother-in-law and his mum wrote, saying, we're really, really concerned, this is not the Nick we know, things have changed very badly, we've sat down with Nick to talk about how he's feeling, things are really worrying for us. That's why I put up, when we talked about this, that list of feelings that you worked up with your older sister, Bernadette. I find that really powerful and very moving, because Nick's family were trying very, very hard to support his voice and make sure that Nick was listened to. But nobody was listening to them either. So it's been very frustrating hearing your story, because there seem to have been a lot of missed opportunities right from day one, from the point where you started to experience depression, all the way up until you got sent to trial. And then that was actually the point where you got specialist help. And that's ridiculous. That's not a sensible way to run a social services system. So when we worked on this presentation together, we listed some of the points where it would have helped if people had listened to you and your family and thought about what you wanted and not what was convenient for them or what was affordable or what they thought was best for you. So I don't really understand why they thought it was a good idea in January 2005 to turn up on the doorstep and just ask you to move out of the house into a hostel over the road and then forbid you to go home and see your parents. Because that wasn't what your family wanted, and it wasn't what you wanted, and they did it with just 20 minutes notice with a police officer there. But, so nobody's voice was respected there, and that decision doesn't make a lot of sense. On the medication, it doesn't seem that you were given a lot of information about medication at any point, and that means that also when the medication wasn't working and wasn't helping you, nobody reviewed and checked if you needed to come off some of the medication you were on, or lower the dose, or whether you were actually taking it correctly. Some of the medications you were taking, you were told just to take when you needed them. Like
you took it overdose at one point, so I was feeling down, so luckily I'm still here, but it could have been a lot worse.
Again, you needed a lot more.
Yeah.
People needed to listen to you and understand what you knew about your medication and whether it was helping you, and if you needed it at all. And legally, at the police station, it would have helped, I think, if you understood what it meant to accept a caution before you decided whether that was what you wanted to do.
Just on that point, Neil, I find that term accept a caution.
Sorry.
What does it mean? What does it mean? What does it mean accepting?
So the police, once they had interviewed Nick, they had evidence that he had been carrying a knife, which is it's a crime only if he had intended to use that small knife to harm someone else. Actually, in the interview, Nick had said he intended to use the knife to harm himself. They then needed to make a decision. If they charged him with the crime and he went to a trial, that's obviously quite a long legal process. They can also give him what's called a caution, which is basically a slap on the wrist saying, don't do it again. And we record it on your criminal record, but there's no other penalty. There's no fine, you don't go to trial. There's no possibility of a more severe sanction. So in accepting a caution, all you're doing is saying, yes, I did it. That's it.
Well, you accept how the caution is framed, like they could say you were carrying a knife, and that implication was in Nick's case that he was going to use on somebody else. So like if they said you were carrying a knife to harm yourself, that would have been a caution, like can you reject a caution?
Yes, you can, yes.
Yeah, can you, until you're happy that it is...
The implication of accepting the caution is that Nick had intended to use it for somebody else, because that's what the offence means. And clearly, he didn't need to. He could have said, no, I won't accept a caution because I'm not guilty of this offence. If he'd received legal advice, that might be what the solicitor would have said. And then the police would have had to decide, well, do we want to charge him with the offence and have the administrative hassle and the expense of going to a trial, or shall we just let it drop?
Okay.
Do we not have enough evidence?
So if you reject the caution, they have to make a decision whether they want to bring it to... Okay.
Yes.
Okay.
So it's a little bit like, you know, you're haggling at that point.
Sorry, and can you give a caution without can somebody be given a caution without there being represented legally? If it has an implication about their future standing?
You had been offered the option of a solicitor, hadn't you?
Yeah, I just wanted to get that, basically.
Getting a solicitor to the police station would have taken another 4 hours, and Nick wanted to get the interview out of the way.
You probably wouldn't have known that the solicitor was going to
Yeah, I didn't know.
make a difference.
Made a difference. I didn't think it made a difference, basically. Well, honestly, yeah. Didn't think it made any difference at the time. So, yeah.
Can I just ask, sorry, Nick, about when did you actually get diagnosed with Asperger's?
2004.
So it wasn't until
2004 September, yeah.
Okay.
Yeah.
Had you experienced anything before that? In your education? Or
Yeah, I didn't. I was like a slow learner. Like had learning difficulties. It was a bit different at school. Found it hard to make friendships. So yeah. So yeah, I did have a classic sign.
Any supports at school?
No, I had like a special needs department, but it wasn't. It didn't really know how to like support me. So it weren't really. Yeah.
The psychologist who diagnosed the Asperger's, Nikki had actually seen as a child.
Okay.
And my parents had got her involved, and at that time she didn't. I don't think she knew, but then later on when she then saw Nick again, she said, oh, like very quickly she was able to say, yes, he's got Asperger's syndrome, which was quite interesting.
Could I make a point that it's a common complaint in police stations and guard stations in this jurisdiction that the police officer who's responsible for the welfare of an arrested person either doesn't see fit to get them a doctor to assess whether they should be interviewed at all, or to get them a lawyer to give them advice, and in some cases to insist on them having a lawyer?
Well, frustratingly, we have a mandatory system of support for what's termed vulnerable adults under legislation in England and Wales. So under the Police and Criminal Evidence Act, Nick had to have what's called an appropriate adult at the police station, and you did.
Yeah.
You had an appropriate adult there. And the role of the appropriate adult is to safeguard the welfare of either the young person or vulnerable adult they've been called to support. But the appropriate adult who attended your interview didn't comment on the fact that there was no solicitor present, didn't question whether that was appropriate, and didn't question whether it was appropriate for Nick to make a decision about accepting the caution afterwards. So the safeguard failed. So it exists, but it didn't help. And that raises some questions for me about the usefulness of that safeguard, because it was applied, but their role was to say, this guy needs legal advice.
In the criminal justice system under the UK, isn't there an obligation on the part of the trial court, the magistrate in this particular case, to exercise a discretion on whether that particular confession, I will call it a confession for purposes of the caution?
Yeah.
Yes, because what you have noted, what you have indicated is that Nick wanted this interview to get out of the way, which raises an issue of maybe compulsion, like being forced under the circumstances to adopt that particular procedure. And now when he went to court, was the court obliged anyway to admit that particular piece of evidence, or there was a discretion, first of all, to ask Nick if it was true that such a confession was obtained from him. If so, whether it was forcibly or freely and voluntarily under the circumstances. Bear in mind the judge's rules. The judge's rules, like the rule, he wasn't given an opportunity to
The caution is irrelevant to Nick's later trial, because Nick's later trial was for a separate set of offences. Nick was tried in,
2004.
So he was later tried for committing ABH, actual bodily harm, and criminal damage after being restrained at the hostel and breaking a window. Oh, sorry, glass in the door.
Was the court obliged then to take that particular piece of
Well, he had a solicitor at that interview, didn't he?
Yeah, he did, yeah. It's a no comment, I think, no comment interview, that was it. So I told, yeah.
And then he pleaded guilty.
And I told plead guilty, yeah, but they didn't didn't explain what guilty, not guilty means. I thought I did the right thing, basically. I thought I did the right thing by saying, not guilty, yeah.
Anyone told you to do.
Yeah.
Like a robot.
Robot, just do what people say, yeah.
If we put that in context then, what happened to Nick is almost the definition of the problem Trilentia was trying to describe in her presentation. Because Nick's liberty was restricted by the state. You were told you had to live in this hostel, you couldn't go and see your family, you had to do certain things, there were conditions on your behaviour. When you were frustrated by that and acted out because of that, you were restrained. And then, as a result of that, the state totally deprived you of your liberty in prison. That's actually almost the plot of the trial. We are literally Kafkaesque. So the big challenge for me as a respondent is trying to think, when the legal system has created so many, we are in an adversarial system here, not an inquisitorial system, and in that adversarial system, everything is predicated on the autonomy of the defendant. Nick made all these choices. I don't want to have a solicitor, or I will make a no-comment interview, or I will plead guilty. So at every stage the process was fair because you chose this. This is the situation you ended up in because these were the choices you made. So it's all fine. Even though if you step back from the canvas a bit, it looks manifestly unfair. And trying to work out how we paint the picture differently is the challenge I now have. I haven't worked out the answer to that yet. But at least I have a better understanding of the problem because I've had the privilege of hearing Nick's story. So.